Hello friends, in the series on the income tax cases, today we will discuss a very important case of SURESH Kumar AGARWAL versus Union of India and others. This case has been reported in 456 ITR at page number 148 and the matter has been decided by JHARKHAND High Court and the date of the judgment is 29th August 2022. This case is regarding prosecution of the Assessee under section 276 CC for the failure to furnish return of income. I want to bring to your knowledge that do not take the filing of the return very casually. People have the impression in their mind that if they will delay the return of income, then it is their right to get the return of income delayed and they will have to pay some extra money in the form of interest. But they must be aware of section 276 CC, which gives the power to the department to initiate the prosecution proceedings against you for not filing the return of income in time, and that is within the due date. The facts of the case is like this. In this case, the assessee didn't file its return of income within the due time which is allowed to the assessee, which is generally 31st July or you can say 30th September. There was some matter which was before the CIT appeal regarding the protective assessment of the assessee, and that protective assessment was also deleted by the CIT appeal and the penalty was also deleted. But the assessing officer find that the assessee has got its return delayed and initiated the prosecution proceedings against the assessee. The assessee was before the High Court and the plea of the assessee was that if the assessee has deposited the interest for late filing of the return which was imposed by the assessing officer, then it should be presumed that the department has extended the time limit for filing the return of income. Or you can say it was the plea of the assessee that when I have deposited all the due tax, all the due interest and my protective assessment, even the protective assessment was deleted by the CIT appeal, then there is no element of guilt and mention on my part and the prosecution proceeding should not continue. When the High Court heard this matter, Jharkhand High Court was of the opinion that if the assessing officer has levied the interest for late filing of the return and the assessee has deposited that interest and the department has accepted that interest, then it should be presumed on the part of the assessing authority that the assessing authority has extended the time for filing the return of income. Friends, this case is very important because my point is that for any mistake, for any breach of law, there should not be multiple punishments. Like for filing the return not on time, you take 234E penalty, you take interest, and sometimes you also impose penalty, and then you go for prosecution. These are fiscal laws. The citizen of India contribute to the tragedy of the government, but it may happen that due to some unforeseen events, the assessee gets its return delayed. So he should not be or she should not be dragged to the courts for prosecution. So this is a very welcome judgment in which the court said that if the department has demanded the interest and the assessee has deposited the interest and the department has accepted that interest payment and has taken the interest payment, then it can safely be presumed that the department has extended the time for filing the return of income and prosecution is not valid in these cases. Friends, if I draw some analogy from this judgment, then there are very harsh provisions that when the return is delayed, the losses are not carried forward for that year. So whether this analogy can be drawn for those cases also, that if my return is delayed, then it should be presumed in that case is also that the department has extended the time for filing my return if I have deposited the interest, and my losses should be allowed. At the end of this video, once again I am repeating the name of the case. The name of the case is SURESH Kumar AGARWAL versus Union of India and others. And this case has been reported in 456 ITR at pin number 148, and the matter has been decided by Jharkhand High Court. And